That rule 4.3, dealing with unrepresented person. In dealing on behalf of a client with a person who is not represented by counsel, a lawyer shall not state or imply that the lawyer is disinterested. When the lawyer knows or reasonably should know that the unrepresented person misunderstands the lawyer's role in the matter, the lawyer shall make reasonable efforts to correct the misunderstanding. The lawyer shall not give legal advice to an unrepresented person other than the advice to secure counsel. If the lawyer knows or reasonably should know that the interests of such a person are or have a reasonable possibility of being in conflict with the interests of the client. Now, these unrepresented persons, known as the petitioner and the respondent, that the petitioner didn't have any legal help in her motioning of the court for petition for dissolution of marriage. And of course, there's this thought that as an unrepresented person, when I tell the court that I don't want a divorce, that the county commissioner intentionally violated all my rights because of their thought that since he doesn't have an attorney. See, numerous times, employees of the government have told me that I need to secure counsel. And I told them no, it's against the law. You cannot violate the rights of American citizens. You can't say, well, we're just going to do this right now. You just can't do it. And considering the dealings with the unrepresented person known as a respondent of the dissolution of marriage, that did respond within the 90 days, did take the children in the middle class, there was this thought that you intentionally violated all of my rights when dealing with an unrepresented person. See, my thought was you respond and you wait for the next summons, notice, or subpoena. And then you give the person the response to the response. And then you set a court hearing. Then the respondent appears in court and he tells the judge what he thinks. And the petitioner tells the judge what she thinks. And then you set another court hearing. The respondent gets notice of that court hearing. Then each of them go back to their respective residences. And they both, as unrepresented persons, prepare whatever it is that they want each other to consider. And you go back to court, you give the information to the judge looks at both sides. Right now! I thought that's how it worked. See, unrepresented persons, known as the ex parte per se, petitioner for dissolution of marriage, and the respondent ex parte per se, each one of them goes to court with the idea that I present the information to the judge, so as to negotiate, the custody of the minors named, how much child support will be, and what the parenting plan is right now. Now, it looks to me that you violated, okay. No, you're going to get me, Paul C. Budnick, the unrepresented person. Because my thought is,